The Constitution says appropriations do that cover and program appropriations?
That is correct, Your Honor, but we have to understand the underlying reason for that particular provision. And as I explained earlier, we are referring to the BESF. The total amount of 5.7 trillion, Your Honor, was not changed in the GAA. It's still the same because we are only looking at the obligation side, referring to programmed appropriations and automatic appropriations. The inclusion of the unprogrammed appropriations is there, only on standby. But it does not constitute the obligational, the list of obligations that the government will have to comply as for its operation. Time that current expenditures are being made.
Is it accurate to say that the difference of accumulated revenues and the cost of current year's expenditures is the reserve fund? Is that an accurate statement?
Well, let's say for this year, Your Honor.
No. Just answer that. Yes or no?
The reserve fund
Savings has acquired a definite technical meaning in the GAA and also in jurisprudence. So savings actually refer to those amounts which form part of appropriations, but which have now been saved, so to speak, because of efficiency in operations or because the project or the program has been completed or because the program or the project has been abandoned. So in that case, Your Honor, that part that had been saved under the law may be transferred to other items or may be used to augment other items of appropriations by certain well-defined officials of the government, namely the President, the Chief Justice, the Senate President, the Speaker of the House, and the heads of the various constitutional commissions.
You must be referring to Section 77 of 2024 General Appropriation Act.
I think so.
There are, you mentioned, two sources of savings. These are portions or balances of release appropriations that have not been obligated, free from encumbrance, arising from those two that you have just mentioned. You mentioned about completion or final continuance or abandonment of a program, activity, or project for which appropriation is released. You mentioned about efficiency. That's implementation of measures resulting in the improved systems and efficiencies. Now, what about unpaid compensation and other related costs due to vacant positions and leave of absences without pay? Can you not consider that as also a possible source of savings?
From a general or generic point of view, Your Honor, if those plantilla items have not been filled up, then in a general sense, this could be considered likewise as savings.
Does the law, I referred to Section 77 of 2024 GAA, make an exclusive enumeration regarding sources of savings? It mentioned only two, but you are espousing the theory that that may also be a possible source of savings.
Yes, Your Honor. I think, I'm not too sure though, but the word among others might have been used in Section 77.
I ask that because that is provided for in GA 2014, Section 59. It is not mentioned in Section 77 of 2024 GA. So that crops up the question whether it still forms part of the savings, but the law does not say only any. In any case, so may I now ask the petitioners in charge of special funds? I will back to it later on. In charge of, I understand that you divided the issues among yours, among the council. So, yeah, thank you.
With the permission of the Honorable Chief Justice.
Well, given this PowerPoint presentation, is it not possible that the source for unprogrammed appropriations may come from Y, which we term it as other portion? What do you think? Can that be the possible source of unprogrammed appropriations?
Your Honor, for me, what is clear is that per admission by the government, as labeled in the GAA, the one that was taken away, the 60 billion so far, came from sin taxes, Your Honor, because the GAA says this is the appropriation for sin taxes.
Yes, answer yes or no, or no.
No, Your Honor.
The reserve fund is isolated. It must remain untouched. That's why there is a barrier there,
Yes, Your Honor.
which implies that reserve fund must be untouched,
Yes, Your Honor.
isolated from the other portion.
Yes, Your
Now,
Honor.
the respondents, please, Solicitor General, is that the one that the government has been doing, that it may source such unprogrammed appropriations from the other portion,
Exactly, Your Honor.
not from the reserve fund?
No, because precisely the DOF circular clearly stated that the GOCCs shall review and reduce to a reasonable level their reserve funds, taking into account their historical expenditures for the previous years. And the remainder, meaning outside the reduced or reasonably reduced reserve fund, will be the base for the computation of what should be remitted back to the Treasury. And in that particular example, Your Honor, your Y factor, which refers to the accumulated revenues over the past years, in the case of the PDIC, which is the other GOCC that remitted funds to the National Treasury, these are the unrestricted funds. These are the retained earnings of PDIC, precisely your Y factor. And that was the amount that was determined to be returned to the National Treasury.
Any refutation?
Yes, Your Honor. In the Bureau of Treasury's presentation for the House of Representatives on May 8, 2024, they determined the fund balance as from 2021 to 23 as premium for indirect contributors minus benefit claims. So that's for 2023, 38.8, and then for 22, 24, 2021, 27.1, for a total of 89.9 billion.
We have repeatedly mentioned fund balance. Where in that presentation is the source of the so-called fund balance?
Where in the presentation? That's actually my quandary, Your Honor, because they, based on the presentations, they just got it. They just computed it based on their subsidy minus the benefit claims from indirect contributors. That's it. That's how they determine
Do
it.
you espouse the theory that it may come from the reserve fund
Yes, Your Honor.
to refute what Solicitor Generals just espoused?
Yes, Your Honor.
Thank you. Yeah, I will ask additional questions.
Thank you, Your Honors.
Thank you. Paragraph 3 of Section 11 of Republic Act 11223, Universal Health Care Act, says no portion of the reserve fund shall accrue to the national government, any of its agencies or instrumentalities, including government-owned or controlled corporation. How do you now reconcile this clear prohibition with the directive of the Department of Finance under the purported mandate of GA 2024 to remit the money to the National Treasury?
Your Honor, the prohibition refers to any part of the reserve fund or income thereof or therefrom from being remitted back to the general fund of the National Treasury. Precisely, this is what Special Provision 1D and DOF Circular 003 provided, which means that you make your own review of your reserve fund and the remainder, meaning outside of the reserve fund, is what will form the basis for the computation of any amount that is unrestricted and will be returned to the National Treasury. So very clearly, Your Honor, the reserve fund had already been set aside, and it's only the remainder from the computation of the unrestricted funds that may be the subject of a transfer or a return to the National Treasury. So there is no violation, Your Honor.
As early as in 1961, the Supreme Court, in the case of Henry, Archbishop of Manila versus Social Security Commission, your number L-150045, promulgated on January 20, 1961, held that funds contributed to the Social Security, at that time, Commission, created by the Social Security law are not public funds, but funds belonging to the members or contributors held in trust by the government. Is that ruling of the court applicable to this case?
No, Your Honor, that is not applicable because the sources of funding for the Universal Health Care Act do not come solely from the contributions by way of premiums of the members of PhilHealth. There are many other sources of funding for the Universal Health Care Act which do not come from, let's say, the paying members of PhilHealth. That is only a part of the funding sources for the Universal Health Care Act.
Okay,
By and large, the majority is from taxes.
Let's delve into Article 6, Section 29, Paragraph 3. That's the Special Purpose Fund.
Yes.
That's a constitutional provisions which says all monies collected on a tax levied for a special purpose shall be treated as a special fund and paid out for such purpose only. If the purpose for which such a special fund was created has been abandoned or fulfilled, the balance, if any, shall be transferred to the general funds of the government. Do you know of a decided case wherein the Supreme Court made mention of this special fund?
Your Honor, I do not recall right now the title of that case, but I know a legal basis for making a distinction between what is known as soft earmark and hard earmark. There is a provision, Your Honor, in the Administrative Code, the revised Administrative Code, that, if I may refer to my note, Your Honor.
Yes, please.
Executive Order number 292, Book 6, Chapter 5, Section 44, heading Accrual of Income to an Appropriated Surplus of the General Fund. And it says, Your Honor, unless otherwise specifically provided by law, all income accruing to the departments, offices, and agencies by virtue of the provisions of existing laws, orders, and regulations shall be deposited in the National Treasury or in the duly authorized depository of the government and shall accrue to the unappropriated surplus of the general fund of the government. In the following section, Your Honor, Section 45, the heading is Special, Fiduciary, and Trust Funds. And I quote, receipts shall be recorded as income of special, fiduciary, or trust funds, or funds other than the general fund, only when authorized by law, and following such rules and regulations as may be issued by a permanent committee consisting of the Secretary of Finance as chairman and the Secretary of the Budget and the Chairman, Commission on Audit, as members. So what I'm saying, Your Honor, essentially is if the law does not provide or create a special fund or a special trust fund, then any such income shall go to the general fund of the national government.
With all due respect, the Supreme Court in the case of Gaston versus Republic Planters Bank, jar number 77194, promulgated on March 15, 1988, the court had the occasion to enunciate a doctrine on this, and this is what the court said. Revenues that are levied for a special purpose shall be treated as special fund, which are administered for that purpose only. Once purpose has been, for which the funds was created has been fulfilled or abandoned, the balance, if any, shall be transferred to the general funds of the government. My question is, one of the sources of funds to implement the universal health care system is the total increment of the sin tax collections. Can we not consider these funds that may be derived from the sin tax collections as funds considered held in trust by the PhilHealth?
No, Your Honor. Let me refer to Section 37 of the Universal Healthcare Act. Your Honor, if I may.
Yeah, please, proceed.
Referring to the very last paragraph, Your Honor, of Section 37 of the Universal Healthcare Act, may I quote, "The amount necessary to implement the provisions of this Act shall be included in the GAA and shall be appropriated under the DOH and national government subsidy to PhilHealth. In addition, the DOH, in coordination with PhilHealth, may request Congress to appropriate supplemental funding to meet targeted milestones of this Act." The implication, as far as I'm concerned, Your Honor, seems to be that all of the sources of funding, including those arising from the sin taxes, will have to go to the general fund and to be eventually appropriated by Congress under the DOH and national government subsidies to PhilHealth, presumably taking into account the amounts collected from the various sources, such as the sin taxes. That is my understanding, Your Honor, but it is not the same as this law creating or providing for the creation of a special trust fund like the Coco Levy Trust Fund, which is set apart from the general fund of the National Treasury. Here, the law itself very clearly states that the amounts necessary to implement the provisions of this Act shall be included in the GAA, Your Honor.
My final question deals with Article 6, Section 25, Paragraph 1. Under this constitutional provision, Congress may not increase the appropriations recommended by the President as specified in the budget. Petitioners in GR number 275-405 claimed that there is an additional insertion of 449.5 billion to the unprogrammed appropriations, which originally was set at 281.9 billion. Clearly, there is a huge increase in that the total unprogrammed appropriations ballooned to 731.4 billion. The legislative intent of this prohibition, according to the Constitutional Commission, is to prevent enormous budgetary deficits. How does the bicameral conference committee account for such enormous increase? Is this not a clear contravention of this constitutional provision?
No, Your Honor, because that provision applies the prohibition to increase the budget submitted by the President does not refer to the NEP or the National Expenditure Program submitted by the President, but it refers to the budget of expenditure and financing, or BESF, which is the budget document specified in Section 22 of Article 7 on the Executive Department as the basis for the General Appropriations Act. What I'm saying, Your Honor, is the purpose of that provision is, as you correctly stated, to prevent any budget deficit, any humongous or any very large budget deficit. That's why Congress has to look also at the funding or financing side, not only the expenditure side, like the NEP. Now, since the concept of unprogrammed appropriations is something like on standby, only when funds are available, only when there is an excess collection from revenue, only when new foreign loans are granted, then that is not counted for purposes of determining whether there might be a budget deficit, because it will only come to play when the corresponding funding would come in. That's why it's unprogrammed appropriations, Your Honor.
Well,